U.S. Supreme Court late Friday essentially communicated that the governor of Nevada, Steve Sisolak, was okay in his policies favoring casinos over constitutionally protected churches in the state's coronavirus restrictions. The 5-4 decision allows the state to keep in place more onerous restrictions on churches than casinos, restaurants, and indoor amusement parks. Now, Justice Kavanaugh, in his dissent, wrote very succinctly, and I think clearly, quote, "Nevada is discriminating against religion," end quote. So are such decisions by the court undermining the rule of law and fueling government distrust in our country? Joining me now to talk about this and about the ending the guessing game of a Supreme Court nominee's judicial philosophy is Missouri Senator Josh Hawley, a member of the Senate Judiciary Committee and the former Attorney General of the state of Missouri. Senator, welcome back to Washington Watch.
Thanks for having me.
I would just put this before you. Are we not in trouble when the Supreme Court cannot distinguish between a constitutionally protected right, the free exercise of religion, and the ability to go in and play slot machines? If we can't distinguish between those two, I would suggest we're in trouble.
Big trouble. And not only because, Tony, this disparate treatment is a problem, but the truth is the First Amendment to the Constitution of the United States gives churches and the right to worship a special status. I mean, it's bad enough that churches in Nevada and elsewhere are being treated as second-class institutions and treated worse than liquor stores or gambling halls or casinos or whatever else. That's bad enough. But in fact, the Constitution gives them a special protected status, and this court is so far from recognizing that. This decision on Friday is really a travesty. It is totally unjustifiable, and I think it's quite significant that the majority was silent. They didn't write. I'd love to see them try to explain this outrageous decision.
You know, I'm not surprised at the order from Governor Sisolak because when you look at Nevada, they generate over a third of their state's budget comes from casino revenue. About $1.5 billion annually comes from casinos, and they do not generate any monetary value over churches, although I would argue that the value of the churches being active is much more important to the overall climate and stability of the state. But for the Supreme Court, I mean, their focus is on the Constitution. That's it. That's all they need to do. And in this case, they took a pass, allowing these stringent regulations on churches to remain intact. And I go back to what I opened with, Senator Hawley, because you've been an outspoken defender of the Constitution. But when we have a country that is ruled by law, the Constitution being that rule of law, and that's undermined by the court, what we see is government is undermining its own authority, and people begin to distrust government more and more.
Well, in this case, Tony, I think it's even worse than taking a pass. What the court did on Friday is they endorsed, a majority of the court endorsed this discriminatory set of practices by Nevada. It's also happening in California. It's happening in a number of states across the country where churches are being singled out for disfavor. I mean, once again, in Nevada, you can have casinos, including, by the way, the casino's convention center, their stage and arena areas. Those can all be filled at 50% capacity, which could be hundreds and hundreds, I don't know, maybe thousands of people. Yet churches are limited to 50 total congregants, no matter what the size of their building is. It's just, this is discrimination, pure and simple. It has gone on for too long. I've asked the Justice Department to open a civil rights investigation into this issue and into every state that is practicing this form of discrimination. But we should not lose sight of the fact that the United States Supreme Court is falling down on its constitutional responsibilities here. And I have to say, this is really of a piece with what we have seen from this court. The imperial judiciary lives, Tony. It is alive and well, and this Supreme Court is as imperial a court as we have ever had.
But does this not undermine the rule of law in our country when we can't even go by the very words that are in the Constitution?
It absolutely does undermine the rule of law. Basic tenet of the rule of law is that citizens are supposed to, A, be the lawmakers, either directly or through their elected representatives. B, everybody is supposed to know what the law says and is. In this case, we've got elected officials in some states Court disregarding the laws of probably their states and certainly of the United States Constitution. And we have a United States Supreme Court that thinks that it's a super legislature, that it can just make up the law as it goes along, or in this case, bless and condone the unconstitutional acts of state officials. And who's to say, Tony? I mean, the way that the Supreme Court has treated these church cases, we'll just have to find out in a later case what the rules are. I mean, they change with the case. Who knows? So this is antithetical to the rule of law. It's very dangerous.
Well, and when we come back from this break, we're up against a break, we're going to talk about a remedy that you have put forth when it comes to the judicial philosophy of Supreme Court nominees. You've basically said over the weekend the guessing game has to end. And we're going to talk about that on the other side of the break. Folks, don't go away. Senator Josh Hawley of Missouri, a member of the Senate Judiciary Committee, joins us next to talk about ending this guessing game. It's kind of like you never know what you're going to get when a Republican nominates a Supreme Court justice. He has a remedy. We talk about it next here on Washington Watch. Don't go away. All right, over the weekend, a Washington Post story, an interview with our guest that is joining us right now, Senator Josh Hawley of Missouri, a member of the Senate Judiciary Committee, has made some waves. And I would say it's about time. For far too long, as the senator has articulated, conservatives have sat back in the corner and been quiet and been content to take promises that have never been fulfilled. Not any longer. He said, I will vote only for those Supreme Court nominees who have explicitly acknowledged that Roe v. Wade is wrongly decided, meaning that they have been on the record before they were nominated about the case. Senator, those are pretty strong words and have drawn quite a reaction.
Well, it's time, Tony, that we ask a question that is fundamental to a judge's judicial philosophy. And Roe was an unbridled act of judicial imperialism. It's also a moral outrage. It's one of the worst decisions ever handed down by the United States Supreme Court. It's completely lawless. It belongs with Dred Scott and Plessy versus Ferguson as decisions that have wounded the soul of this nation and that are completely without justification in the Constitution of the United States. And I want to know from any individual, judge or whatever, nominated to the United States Supreme Court, whether they are able to recognize the illegitimate nature of Roe versus Wade as a constitutional matter. And I want to see it in the record. I don't want private assurances. I don't want personal predictions about what they might do in the future. I want to see record evidence that as a matter of law, they recognize that Roe versus Wade is wrongly decided. If that's not there, if that evidence is not there, I will not vote for it.
Senator, I applaud that position because we have, in my almost 20 years of being in this position, we've had to oppose Republican nominees because we were told, no, they're going to be good. They're going to be good. How can you tell me? Well, we just know, even though they had, in some cases, a paper trail that suggested they were not good. And we've even seen on the present court with the Chief Justice, where he has lined up repeatedly with the court's liberal now majority of 5 justices. This is a fundamental issue. The issue of the sanctity of human life, created from the shadows of the Constitution. And you're absolutely right. If you don't get this right, it's very unlikely you're going to end up in the right place on other issues.
You know, Roe really is a symbol of judicial imperialism. Roe is the point at which the modern Supreme Court, back in 1973, the modern Supreme Court said, we're not even going to attempt to follow the Constitution. And there's a famous line by the late liberal constitutional scholar John Hart Ely. He was a Democrat, political liberal, and he said this about Roe. He said, it's not constitutional law, and it gives almost no sense of an obligation to try to be. And that's exactly right, which is why a judge's position on Roe, the understanding of that case as a legal matter, sheds great light. It is a window onto their constitutional worldview. And the simple fact of the matter is, if you can't recognize that Roe was wrong constitutionally, then you are a judicial imperialist. And that's going to have consequences across a range of cases. It's a basic matter of constitutional fidelity.
So, Senator Hawley, I want to talk about the practical implications of this position that you've stated, which again I applaud. But there are 12 Republican members of the committee, the Senate Judiciary Committee, through which all nominees, judicial nominees, must pass. There are 10 Democrats. If you do not support a nominee and all the Democrats oppose them, that becomes 11-11, which would mean that the nomination, if I understand it correctly, would not succeed. It would die because it did not get an affirmative vote. So this, for the first time, actually puts conservatives in a position to influence the nominees that are put forth before the committee.
This, I hope, will be a signal that I'm very serious about it. And you're right about the vote counting. And, of course, who knows what the votes of the Judiciary Committee will be in years to come. But right now, one Republican no vote would mean that, at least at the very least, Tony, a nominee could not be recommended to the floor with a positive recommendation for the Judiciary Committee. But I think it is important to make your position here clear. Other senators have made their position clear with regard to Roe and on other issues. And I think it's important that those of us who believe in fidelity to the Constitution and who also believe that Roe is a moral travesty as well as a constitutional travesty, that we make our position clear and insist that, no, Roe is not some secondary matter. It is central to a judge's philosophy. So I'm just saying it's not my job to choose the judges or the justices to be nominated. I only have one role in this process, that is to vote to confirm or not. And I'm just saying that I will not vote to confirm if a judge nominated for the Supreme Court has not acknowledged Roe is wrongly decided.
Well, again, Senator Hawley, I commend you, because for far too long, conservatives have been silent while the moderates have spoken up and driven the process and the type of nominees that have been put forward. And I'm with you. I am 100% with you in the position that you've articulated, and we're grateful for you standing up for the Constitution and for the unborn. Thanks so much for joining us today.
Thanks for having me.